it amounts to irregular marriage. And marriage with the fifth wife, that is, though the man is allowed to get married 4 times or is allowed to have 4 living wives, if he gets married for the fifth wife, fifth marriage becomes irregular. And marriage during iddat, that is, a lady is supposed to or is expected to observe iddat after marriage, is dissolved either by divorce or by the death of the husband. And if there is a marriage with a lady who is observing iddat, that is also, it amounts to irregular marriage. That is, please note, wherever or whenever there are absolute prohibitions in marriage, the marriage amounts to void ab initio, because the prohibitions are inherent, nothing can be done about them. That is, the parties to the marriage cannot do anything about the prohibition, neither they can repair nor they can cure the irregularity. But to look at the irregular prohibitions are not inherent defects in a marriage. They can be cured, the irregularity can be taken out. Once the irregularity is taken out, the irregular marriage becomes the regular marriage. Like, say, for instance, in the case of unlawful conjunction, when a man gets married to two full sisters, he can divorce one of them, and if the marriage is not witnessed by two proper witnesses, he can ask, or he can have two proper witnesses. And marriage during pilgrimage, that is, after he comes back from the pilgrimage, he can the marriage becomes regular. And if the if he if, in the case of marriage with the fifth wife, he can divorce one of them, so marriage becomes regular. And marriage during iddat, when a lady is observing iddat, if he gets married, the iddat period will have to come to an end. After the iddat period comes to an end, he can contract a fresh marriage, and that becomes a regular marriage. That is the case of irregular marriage. That is, whenever the relative prohibitions, Muslim law says that it becomes a irregular marriage. And in the case of irregular marriage, if the irregularity is cured, the marriage becomes regular. But Shias don't accept this. Shias say that irrespective of the absolute prohibition or the relative prohibition, the marriage amounts to void ab initio. That is, Shias opine that whenever there is a prohibition, the marriage becomes void ab initio, and they don't recognize irregular marriage. Let's move on to the different kinds of marriage in the Muslim law. The first one is valid marriage, that is, as we have already discussed, when all the essential elements of a marriage are present, then we say that it becomes a valid marriage. Void marriage results whenever there are absolute prohibitions and polyandry are present. That is, of course, Shias is an exception. Shias say that whenever there is a prohibition and polyandry, it amounts to void marriage. And when I say polyandry, I mean to say that a married woman is not allowed to get married to another man. And the third kind of marriage is irregular marriage. That is, wherever there are relative prohibition in a marriage, such marriages amount to, or such marriages are called irregular marriage. And the other kind of marriage is muta marriage. Of course, it is not in vogue anymore, it is not practiced anymore. This kind of muta marriage was prevalent among Ithna Ashariya Shias, and they were of the opinion that muta marriage could be contracted by a Muslim man whenever he goes on a trade journey, whenever he goes to fight a battle or war. That is, muta marriage is a temporary marriage which could be contracted by him only when he is away from the family, only when he is away from his wife, not while living with the wife. What is this muta marriage? Muta marriage is a temporary marriage. An adult, or if a person or a man who has attained the age of puberty, that is 15 years, could contract this temporary marriage with a Muslim woman who was also of the age of puberty, 15 years, and both of them should be sound mind, free consent, and the time period is fixed here. The consideration is also fixed. That is, if a woman agrees to stay with the man for a fixed period of time, at the end of the fixed period of time, he is supposed to pay the agreed consideration. And of course, it was up to the parties to mota marriage, either to break the marriage or to stay. And once the fixed time period is over or elapses, the mota marriage comes to an end automatically. There will not be divorce here, and followed by the termination of the term of the mota marriage, the wife will have to observe iddat for 4 months 10 days, and if she is pregnant till the delivery of the child, children born out of such mota marriage were considered legitimate and they had the property rights from the father. But over a period of time, this mota marriage was being misused by the men while living with the wife or while living with the wives, because of which the jurists thought it fit to discontinue the practice of mota marriage, because of which, as on today, mota marriage is not practiced anymore. Last part is iddat. What is this iddat? Iddat is a period of purity or the celibacy that will have to be observed by a Muslim wife, followed by the dissolution of marriage. How does the dissolution of marriage take place? The dissolution of marriage takes place either by the death of the husband or by divorce by the husband. And there are two kinds of iddat: divorce iddat and death iddat. In the case of divorce iddat, as soon as she is divorced by the husband, she is expected, or she has to observe a iddat of 3 months, lunar months, if she is subjected to menstruation, or if she is pregnant at the time of divorce, she has to observe iddat till the delivery of the child. In the case of death iddat, if the marriage is, whether the marriage is consummated or not, she is expected to observe a iddat of 4 months. I am sorry. She is expected to observe a period of iddat for 4 months and 10 days. And if she is pregnant, till the delivery of the child. This iddat is practiced only to ascertain the paternity of a child, because if a child is born subsequent to divorce or the death of the husband, it becomes difficult to ascertain the paternity and maintenance of the child becomes a problem. In order to avoid such a complication, Muslim law has a beautiful practice of observing iddat. And can there be remarriage between the divorced couple? Muslim law does not allow remarriage between the divorced couple unless there is an intermediary marriage, which is called halal marriage under Muslim law. What is this intermediate marriage and what is the procedure for the divorced couple to get married? First of all, if there is a divorce between the couple, the wife will have to observe iddat for 3 months. She will have to contract a fresh marriage with another man. That marriage will have to be consummated. That marriage will have to be dissolved either by death or by the divorce by the husband. Followed by this, she is supposed to observe iddat for 3 months or 4 months, 10 days, as the case may be. After the observance of iddat, then she can contract a fresh contract of marriage with the first husband. This intermediary marriage has been imposed on the Muslim man or Muslim men in order to curb the practice of the Muslim men uttering talaq in haste. And if they repent later, they'll have to follow this cumbersome procedure. So this acts as a check on them, check on their absolute power of pronouncing talaq. Thank you all.